So for example, Article 30 mandates that records should be maintained for all processing activities performed on personal data. Now this is only possible if data-centric audits are possible irrespective of whether the data is lying within the enterprise control systems or they've been sent to data processors and so on. Now this is one of the core capabilities of rights management systems. Another great example is Article 46, which states that a data controller may transfer personal data to a data processor in another country if and only if the recipient entity has provided appropriate safeguards. Now, practically speaking, this is very difficult because data processors may be in any other part of the world, and guaranteeing for anybody to guarantee that it will be in compliance to GDPR requirement is very difficult. But an easier, more data-centric view of this same requirement could be where the data controller can embed security policies, GDPR compliant security policies, and then send the data over to the data processor such that what the processor is doing, for how long, which are the entities who have access to and from which devices and so on, all of this can be controlled by the data controller by its own system instead of relying on the data processor. Article 25 of GDPR mandates data protection by design and by default. Now this is very difficult to implement in existing applications like core banking, file sharing solutions, document management and so on. What these application vendors can do is by integrating with rights management systems, all exports out of the application can be rights management or rights protected such that these pieces of data can be controlled by GDPR regulation irrespective of where they are, by having a consistent, verifiable and auditable data security and privacy policy applicable to data irrespective of whether the data is within the enterprise or outside, and therefore it provides a very elegant solution to the problem of GDPR compliance.